I'm Sylvia Idowu. Glad you could join me on another edition of Handy Law. Today, I'm starting a series on Nigeria's Administration of Criminal Justice Act 2015. I'll take this in conjunction with the Administration of Criminal Justice laws of Lagos, Anambra, Kaduna, and Ogun states. And I'll highlight areas in which these states have made additional input into their laws that is beyond the provisions in the Act. The idea for this new series is to highlight sections of the Act that will equip us citizens for informed interaction and dealings with security agents and institutions. What is the purpose of the Act? The purpose is to ensure efficient management of criminal justice institutions by the courts, security agencies, and other authorities, speedy dispensation of justice, protection of the rights and interests of the suspect defendant, and protection of the rights of the victim. We will start by looking at the procedures of arrest. The Act stipulates how a suspect alleged or charged with committing an offense may be arrested, investigated, or tried. The police officer making the arrest may actually touch or confine the body of the suspect unless the suspect submits to custody by word or action. For instance, if the police tells you you're under arrest, you may stand still and engage them in a civil manner to show you're not resisting arrest. But if you do resist arrest, they will be forced to touch and confine your body. The Act goes further to provide that a suspect or a defendant may not be handcuffed, bound, or restrained, except there is reasonable apprehension of violence or an attempt to escape. A suspect may also be restrained for his own safety. Some people try to harm themselves when they are confined. A suspect may be restrained by order of a court. A suspect shall be told the reason for the arrest immediately, except when the suspect is in the actual course of committing the offense or is pursued immediately after committing the offense or is escaping lawful custody. The police officer or the officer in charge of the station shall inform the suspect of his rights to remain silent and avoid answering questions until after consultation with a lawyer or a person of his choice. To consult a lawyer before making or signing confessional statements. The availability of free legal representation by the Office of the Public Defender or the Legal Aid Council of Nigeria or any such agency. Did you know that the Legal Aid Council is a body set up by an act of the National Assembly, the Legal Aid Act, and is charged with the responsibility of providing free legal aid for indigent citizens? Legal aid may be granted a person whose income does not exceed the national minimum wage. In exceptional circumstances, they may grant legal aid to someone whose income does exceed this. Also, the governing board may approve legal aid on a contributory basis to someone whose income is 10 times that of the national minimum wage. There is an office in every state of the Federation. They have regional centers in the 6 geopolitical zones. Their services cover criminal and civil matters, and they are also charged with the responsibility of educating the public on their services. So go out there and tell someone about legal aid. Some people need it, but they don't know it exists. Enough said about legal aid. Back to Administration of Criminal Justice Act. The Act says that the police or any security agency who has custody of a suspect is responsible for notifying the suspect's relatives of his arrest at no cost to the suspect. We know this is not the actual fact in practice. The police holding stations may not have funding from the government to make these calls. So, if you need to make a call using your phone, please do so as soon as you are allowed to. The Act further says that a person shall not be arrested in lieu of the suspect. So gone are those days when a wife is picked up if the husband could not be found, or vice versa. In fact, the administration of criminal justice law in Ogun State says that if this is done, the court on application must release the person immediately. A suspect shall be accorded humane treatment, having regard to his right of respect to the dignity of his person. He must not be subjected to any form of torture, cruelty, inhuman, or degrading acts. While the intent here is very good, the reality is a different thing. The police holding cells and the prisons in their current condition are degrading to the dignity of many. Hopefully, the government will attend to this soon. It's noteworthy to state here that Ogun State went further by providing that a suspect must not be paraded before the media. If this happens, on acquittal, the suspect will be eligible for damages and compensation. A public apology must be tendered, and the negative publicity retracted by the agency that was responsible for parading him in front of the media. A suspect shall not be arrested merely for a civil wrong or breach of contract. The statutory duty of the police is to maintain peace, law, and order in the society. Debt collection is not within the purview of the statutory duty and powers of the police. The Nigerian police are not agents of debt collection. Citizens owed debts should not enlist the help of the police to recover these debts. Rather, they should apply to the courts for redress and allow the Nigerian police to face more serious issues like combating crime. This is where I'll end this particular segment. As I continue in the series Administration of Criminal Justice Act, next time we will look at the provision for how arrested suspects must be searched. So how much of this did you know? What have you observed in terms of compliance by the relevant security agencies? I'd like to know your thoughts. Please leave your comments. In the meantime, don't forget to like, share, and subscribe.